Welcome to the Ottawa Business Journal's live broadcast of Workplace Investigations, How to Prepare for Any Scenario. I'm Michael Curran from the Ottawa Business Journal. Thank you for joining us today. We have hundreds of people going to partake in today's live broadcast. We're very excited by that. They're on YouTube, LinkedIn, Facebook, Twitter, so welcome to you all. As always, we want to make this an interactive experience for our live viewers, and that means we want to solicit your questions and comments at the end of the show. That will happen sometime around 12:25. Let's set up the show a little bit today. We've got a great one for you. All employers want to avoid scenarios that could warrant a workplace investigation, but in the real world, problems can and will arise. The situation employers may face include harassment, violence, health and safety issues, requests for accommodations, performance issues, and misconduct. In every scenario, the stakes are high and the potential consequences are significant for both parties involved. That's why the best strategy is to be prepared, and that's why you are here today. Here's what we're going to learn in today's show: why conducting a proper investigation is important, the types of scenarios that require an investigation, common pitfalls to avoid, and what happens when you get it right, and equally what happens when you get it wrong. So let's meet our guest today. He is a partner at Eamon Harnden, a locally headquartered law firm that specializes in labor and employment law. Please welcome Sébastien Huard.
Hello, Michael.
That was me practicing my French pronunciation. Sébastien Huard.
Yeah, thank you very much.
Okay. So, Seb, it's great to have you here. And I was reflecting on this topic a little bit, Seb, and something occurred to me, and it's the context in which we're speaking and how things might have changed a little bit in the pandemic, because a lot of us, certainly in kind of white collar type jobs, are in this hybrid environment. We're partially in the office, we're partially at home. So just wondering, does that impact the frequency of harassment or any of these issues?
Yeah, there's really no impact. Whether you're working in a physical setting at your employer's typical workplace, or you're doing so remotely, the same principles will apply. The employer is required to ensure compliance with its policies, compliance with the Ontario Human Rights Code, compliance with the Occupational Health and Safety Act. Those two important pieces of legislation which govern issues, namely of harassment and discrimination in the workplace. And so it's, whether you're working from home or whether you're working physically in your employer's workplace, you're required to engage in proper behavior. And if there is improper behavior, the employer is required to investigate and address those issues to ensure a safe and healthy workplace.
That's good. So it's so the takeaway is it remains as relevant and possible, unfortunately, as ever. We've all heard about cyberbullying and stuff like that.
Absolutely, and whether that occurs through email communications or through team meetings or Zoom meetings, the same principles will apply. So
okay, good to clarify that. So listen, Seb, we're going to give people a bit of a preview of what we're talking about today. We're going to break it down into three parts. The first part is why conducting a proper investigation is so important. So that's kind of the starting point. Number two, what kind of scenarios can trigger an investigation? And that kind of is the yellow flags going up if you're a manager or business owner. And number three, equally important, what are some of the common pitfalls to avoid? And as promised, we'll get to our live audience sometime around 11:25. So let's kick things off, Seb. We got a lot of ground to cover. So topic one, again, is why conducting a proper investigation is so important. I'll turn things over to you, Seb.
Yeah, so one of the first principles is that if an employer elects not to conduct a proper workplace investigation, that may give rise to legal consequences for employer by way of an application to the Ontario Human Rights Tribunal, which addresses issues of discrimination in the workplace. It can also take the form of a constructive dismissal claim, where an employee says, I'm experiencing a toxic work environment, and by your actions, employer, or by the actions of fellow employees, you've effectively terminated me because you've created an unhealthy workplace. And so that is why it is so important for employers to address issues of workplace harassment, or if it's a health and safety issues arising under the Occupational Health and Safety Act, to address issues of health and safety quickly to ensure that you're able to provide a safe workplace. And if an employer doesn't do that, then they may face damages, whether through the Human Rights Tribunal, whether through the court system, or whether through orders that are issued by the Ministry of Labor for where there's an unhealthy workplace. And so there's certainly an incentive for employers to ensure that they are providing a safe and healthy workplace for all of its employees. And the other piece as well is the ability to attract and retain good employees. We're often looking at it just from a legal consequence perspective, but it's also important to ensure that from a human resources perspective, we're providing a healthy workplace so we can attract and retain our best employees. So
I like that point, Seb. So, as is always the case in these employment law discussions, you want to do so just to be a good employer, but then there's a bunch of legal reasons
absolutely.
as well. We should always remember that. And I want to dig in on a couple things on this first topic. Ottawa has a big public sector. We've got a big private sector too. But are there any different considerations when we're thinking a private sector employer versus a public sector employer? And I guess what I'm really getting at there is a private sector versus a unionized environment.
Right. So certainly here in Ottawa, you've got a number of employees that are subject to federal legislation. And so you can put it in sort of a couple of baskets just to try and simplify things. You've got employers that are subject to provincial law. And so therefore you're looking at the Employment Standards Act. And for those that are unionized, then the collective agreement considerations. But the same piece of legislation will apply. So the Occupational Health and Safety Act, Ontario Human Rights Code, and those two pieces of legislation will address issues of harassment, and in the case of the code dealing with issues of discrimination. Discrimination can also take the form of harassment as it relates to a prohibited ground of discrimination. And then in the second sort of basket, you've got employers that are subject to federal law, whether it's the Canada Labor Code or other pieces of legislation that apply to federally regulated employees. But the same principles will apply in the sense that you must address workplace harassment issues or workplace violence issues or workplace discrimination issues. The only difference is that the legislation will be different, and there may be some specific issues that are set out in the collective agreement, which will set out a more stringent or more specific process to addressing investigations. But the same principles will apply across the board. Most employers will have or should have policies that will address harassment in the workplace, violence in the workplace, discrimination in the workplace, and how those issues will be addressed through an investigation, and what's the process that needs to be followed in those specific cases. So.
Okay, that's another good point. So that employers should have guidelines in place to kind of dictate and clarify the scenario for everyone. Just before we move on to topic two, Seb, I wanted to just dig in on that word proper investigation. So we're saying, why conducting a proper investigation is so important. And I'm wondering, there might be people, let's say it's a small and medium-sized enterprise, that they're thinking, well, can we do this ourselves, or does someone need to be hired? Is that a lawyer? Like, what? Give us a sense of what would constitute a proper investigation.
Right. So as a rule of thumb, if you're looking at a pretty straightforward investigation, whether it's and if you take the example of a workplace harassment investigation, in some case it can be done internally. Fairness is key. Important to meet with the complainant, the respondent, so the person who is the subject of the complaint. Collect the information from each party and draw a conclusion. Maybe as well in some cases where you need to meet with a witness or witnesses to corroborate the evidence. And so in some cases it's doable. An investigation can be done internally. That's certainly possible. In the more complex workplace investigation, the general guidance is that you will ask a third party to investigate. Typically there are qualified consultants that can do it. And in other cases, it'll be a lawyer, an experienced lawyer, sometimes former private practice lawyers that have set up shop to engage in workplace investigations, and they will produce a report. And that's often important when you're dealing with complex fact scenarios, or when there's an issue of weighing credibility. Who's telling the truth? And that's quite difficult, when you have to assess who's telling the truth, and you're applying in some cases rules of evidence, and to draw whether it's a negative inference based on the information being provided. So the general rule: complex workplace issues, you want to send it out to a third party, because fairness is important, and it's important to ensure that you're engaging in a proper workplace investigation. If you don't have a proper investigation, then that can lead to legal consequences and damages for employers, and it can also result in a delayed investigation as well. People are busy; they have all sorts of competing obligations in the workplace, and so sometimes it's better off to send out to a third party, ensure that you're able to provide a swift and comprehensive investigation, and try to the extent possible to limit your liability as an employer.
That's excellent. And I guess this is the suitable time to say, if you're uncertain about any of that, you should definitely phone a lawyer.
Correct.
Call Sebastian. We got him right here on screen. But seriously, right? If you seek to undertake your own investigation, you better be very clear on how to create that kind of fairness, and consider both sides, and how to make a decision. You really should get some legal advice.
Absolutely, and keeping an open mind, right? I think
Yeah.
often we may have prejudged the issue, and so it's important to, as much as possible, to keep an open mind throughout the process, and be thorough and complete, and properly document your process, and the information that you're collecting through your investigation. By getting signed statements from the complainant, the respondent, and any of the witnesses. So.
All right. That was excellent. Excellent start. We're going to move on to topic number 2, and we're talking about what kind of scenarios can trigger an investigation. So we're thinking about harassment, violence, health and safety, performance issues, misconduct. Tell us more about what kind of scenarios can trigger an investigation, Seb.
So we talked about it a few moments ago, an issue of workplace harassment. So harassment can flow from an issue of discrimination under the Ontario Human Rights Code. So harassment based on one of the prohibited grounds of discrimination, which can include sex, religion, a disability. And so an employee comes forward with an allegation of discrimination based on the code. There is an obligation, a procedural obligation, to investigate that issue. Harassment can also occur as per the Occupational Health and Safety Act. So harassment in the general sense, the bullying in the workplace. So not related to a prohibited ground of discrimination, but related to harassment in general. And again, there's an obligation in those cases to investigate. And if you don't, the employee can seek an order from the Ministry of Labor, and the Ministry of Labor, through one of their inspectors, will compel the employer to conduct an investigation. And so those are 2 examples where investigations need to occur. Violence in the workplace, again, flowing from the obligations of employers under the Occupational Health and Safety Act. Again, an obligation to investigate, determine if there's been violence in the workplace, and if there has been, then the employer has an obligation to inform the parties, whether you're dealing with violence or harassment, of the outcome of the investigation, and take, where necessary, the appropriate disciplinary action. Workplace injuries. So an employee gets injured at work, there is an obligation under the Occupational Health and Safety Act to investigate. And also flowing from that as well is issues related to the WSIB as well, to inquire, determine if there's been a workplace injury, if there's, what are the contributing factors to that injury, and if there are any, of course, culprits, and with respect to this workplace injury. A request for accommodation. Employee comes forward, has been away from the workplace, and a doctor provides some recommendations about restrictions, limitations. So there's a procedural aspect to the process where the employer must inquire, determine if they're able to accommodate based on the information being provided by the employee, and work with the employee, or in the case of employees unionized, in some cases work with the union to determine what is the best appropriate accommodation in the circumstances. That's the procedural aspect to accommodation in the workplace. And then sort of 2 other reasons why you'd be investigating: if there are performance issues, or if there's an issue of workplace misconduct. And so before you decide to terminate an employee or impose progressive discipline, there's an obligation on employers to investigate, to ascertain whether what's being alleged occurred, and give an opportunity to the person that's the subject of investigation to provide an explanation, a fulsome explanation, and to meet with anyone that may have been a witness or may have brought forward allegations of workplace misconduct. Because before you take action as an employer, it's important to ensure that you've done your homework, you've done your due diligence, and in order to do that, you need to investigate. And so, whether you're investigating a workplace harassment issue, a discrimination issue, or an accommodation issue, same process that applies throughout, in the sense that you're being thorough, you're being very structured in your approach, and you're trying to get to the bottom of to the truth, right? And so that's what you're trying to do as an employer. So
I wanted to ask Sebastien about performance. So, I'm thinking about some of the people who might be watching here today. They own a business, they manage a team inside of a business. As managers, as owners, we all have to give people feedback on performance and say, we need a bit better here. That probably could be considered by some, maybe or even misconstrued as harassment or just a general level of feedback. Is that true? There's a little bit of a slippery slope there that if you become too persistent in negative feedback, that you're going to cross a line at some point.
right, I think the answer to that is an evidence-based approach. So if you're engaging in an investigation and you're providing feedback, and sometimes that feedback is unwelcome. In some cases, employees don't want to hear the truth. They don't want to hear what you have to say about a specific issue. I think it's not so much, am I able to manage employees? The question is, if you are going to be providing feedback, is that feedback that's evidence based? Is that based on reality, or is it a fiction? And so if it's grounded in reality, you've done your due diligence, you've done your proper assessment of the facts, and you provide feedback, and that feedback may be difficult for that person to hear or accept, it's not harassment. And the legislation is quite clear. The Occupational Health and Safety Act is quite clear on that front. And the policies that you're required to develop addressing harassment in the workplace will create a carve out where they will say, as an employer, we're entitled to manage. And these are instances or specific cases where an employer exercising its management rights is not engaging in workplace harassment. And so it's important for employers out there to be comforted by the fact that they can manage, but they must do so in a very structured way. An evidence-based approach is key. And once you've done that exercise, you're delivering a message to the employer. You're doing so in a professional, respectful manner, but you're being very clear in terms of expectations, and you're being very firm about what you need as a business owner or as an organization in terms of reasonable expectations vis-a-vis that employee or your employees.
That sounds like excellent advice. So two things there. One, to be fact-based in providing feedback, right? So things that are objective, right? Here's how you're performing. Here's a measurement of someone else, or here's some observations of very specific things that are problematic or maybe go against a guideline or best practices inside of our business. And then the other thing that you're making me reflect on, Sebastien, is not to take any of that personally. So try to, deliver that in a very unemotional, professional manner to make sure that it's not coming across as angry or anything like that.
That's right. And I will add the following as well. And I know there's a generalized fear among some employers or frontline managers or supervisors to manage. And often the failure to do so leads to other issues down the road. And I'll give you a specific example of that. And employers will sort of tolerate an underperforming employee, and then a year and a half passes, and then they pick up the phone and say, okay, now I'm going to do something about it. And then in the mix of all that, the employee is experiencing sick leave issues or and is seeking accommodation. And then they'll tell us, well, we'd like to part ways with this employee, or we'd like to do A, B, C, D with this employee. What can we do? And there's always the risk for employers that now you're managing the employee following the employee coming forward with an accommodation request, or following an employee returning from sick leave. And so if you have that background whereby the employer has manage the employee. Even if it's not letters of discipline, you've got performance appraisals where you're raising issues about employees' performance in the workplace, and it's documented. And now you decide to take another step in the management of that employee, then it's much more difficult for that employee now to say, well, you're the reason you're taking a specific action in this case is in response to my sick leave request or in response to my accommodation request. You're able to show that there's a history here and that this is not new and it's just a continuum. It's you're continuing in your exercise, your reasonable exercise of your management rights to address a specific issue unrelated to the sick leave issue, unrelated to the accommodation issue. So that's why it's really important to do so, and also to signal to the other fellow employees that the employer has a standard and that the employer is not accepting a B- performance. The employer is expecting employees to perform at an acceptable level and is signaling to other employees what's acceptable behavior in the workplace.
That's more great advice, and probably a reason to have regular performance appraisals. So you're doing this on a regular basis. It's documented. It's formal, and there's expectations on both sides. This is an opportunity for each party to share feedback back and forth. So that's really good stuff, Sebastian. Thank you for that. We're going to go to our third topic. I just want to remind everyone that just in a few minutes, we're going to be coming to you for questions. I'm sure there's lots of questions on this topic. Whether you're on YouTube or LinkedIn or Facebook or Twitter, you can ask the question on the platform that you're watching on, and it'll be consolidated inside our virtual studio here. And I'll be posing some questions to Sebastien in just a few minutes. So this is the time to ask questions in the next few minutes. All right. Topic number 3, Sebastien, we're going to talk about what are some of the common pitfalls to avoid. And we're going to be talking about things like workplace culture, defining harassment, hybrid environments. Let's dig in, Sebastien, to this one.
Yeah, so a few themes here, like not recognizing when there's a need to investigate. That's the first one that I will sort of flag for the audience. And so, for instance, an employee comes forward with an anonymous complaint, or an employee says, Sebastian, here's just for your information. The following things are happening in the workplace, but I don't want you to do anything about it, right? So that's a second example. Or where the employer assumes that the complaint has no merit on its face. So so that's one of the first sort of pitfalls that we see in our practice with some employers. So if an anonymous complaint or an FY type of complaint, there's still an obligation to investigate. The legislation is clear. The Occupational Health and Safety Act makes it clear that you have an obligation to address these issues in the workplace. And even the employee says, I don't want you to do anything about it. Once you've been informed, you have an obligation to act. And you will see from the slide here, this Doyle Zolkin decision, a Court of Appeal decision from 2017. Again, cursory investigation and an incomplete investigation. And you can see from the slide the damages, so 10 months notice based on the employee's age, service, years of service, position held, the traditional Bartle factors, and then additional damages being imposed by the court in light of the employer's conduct in that case. So that's, again, the court's signaling to employer, this is what you need to do to ensure a proper and fair and expedient investigation. A second pitfall is not having an investigation plan. So just like when you're writing an essay, what's your plan? What's the outline? What are you trying to achieve? What is the goal? What is the complaint? Who are you going to meet? The complainant, the respondent, the witnesses. What do you expect these people to say? And you want to sort of set out in writing your plan. What's your plan of attack? And so that's very important. Otherwise, you're fumbling. You're just walking into these meetings with no plan, with no specific objective. So understand the complaint. What's it about? It relates to which policy, which piece of legislation. What information are you trying to extract or get from the complainant? And when you meet with the respondent, what information are you trying to elicit from that person? Are there holes? And you want to perhaps prepare questions in advance of meeting with the complainant and the respondent. And the same thing would go with the witness as well. or any witnesses that you may meet. The third pitfall would be not following policies and your administrative procedures. So have a look at your existing policies, have a look at your collective agreement. What do these documents provide in terms of process? Once you've received the complaint, you know what the complaint is all about, then you have to look to the governing documents. And those governing documents are your policies, your procedures. And so it's important to follow those documents. Otherwise, if there's an unfavorable outcome for one of the employees, they may attack your process by saying, employer, you didn't even follow your own process, and that may have an impact on the quality of the investigation and may have an impact as well on the what a court would view as being a proper investigation in the circumstances. So you want to come to throughout this process with clean hands, and so follow your process, follow the legislation. And one of the important aspects as well when you're dealing with harassment is to inform the parties of the outcome of the process. So the complainant has filed a complaint, the respondent is the subject of that complaint, then they need to be informed of the outcome of the investigation. So that's quite important. So
That's great. And in that particular case, talking about red flags going up, someone makes an allegation of sexual harassment, and you end up dismissing them. That's
right.
you're on thin ice there. I'm sure, Seb. So
absolutely. And another sort of pitfall is not taking interim measures. So you have two coworkers or a supervisor and an employee, and there's an allegation of harassment within the team. And so in some cases, you will want to put in place interim measures, a paid leave of absence for the respondent, separating the parties to ensure that they're not interacting with each other during the course of the investigation. It could be a remote work arrangement, could be a temporary change in reporting relationships, in some cases, maybe sick leave. So you want to make sure that you're implementing those interim measures during a workplace investigation. And another pitfall is not maintaining proper records. So I did speak to that earlier on in terms of ensuring that you've got proper records. So you're meeting with the complainant, you're meeting with the respondent and the witness, you're taking detailed notes, you're not paraphrasing, you're using the words from the complaining, the words from the respondent, and you're asking them to confirm that if what you've collected in terms of information is accurate. So documentation is critical, and you want to make sure you've got proper record keeping during your investigation, because all those documents that you're preparing in the context of litigation will need to be produced at some point. So it's important that what you're putting down on paper reflects reality and reflects the process that you followed in the context of your investigation. And I would say probably the final one is privacy. So if you're dealing with harassment issues or other types of workplace investigations, confidentiality is important. So you want to make sure that you're able to preserve the confidentiality of the process, reminding the parties of that you're dealing with their complainant. So you inform the complainant that you're going to be addressing their issue, that there's a process that you will follow, that confidentiality is critical. They are not to discuss their complaint with anyone. And the same goes with the respondent. And so again, it's all about preserving reputations, right? And so that's quite important in the context of workplace investigations. So.
Thanks again, Sebastien. We've had lots of questions. I've been keeping my eye here on the messages coming in. I'm going to throw a few your way. Lots of fascinating questions. I like this one. So Marcel is asking what to do if someone is uncooperative. So if there's an investigation and one of the parties is simply not cooperating, I presume by sharing information. Any advice in a situation like that, Sebastien?
Right. So an employee, let's say the complainant has filed their complaint and they are not willing to provide any further information, as an example. Then a letter would go back to the complaint saying we've attempted to meet with you on the following dates, or we've sent you the following communications. You've been unresponsive. And so we can only base our investigation based on the information we have. And all we have for the time being is this complaint. So, and the same would go with the respondent, right? So if If the respondent's not prepared to play ball, then you will make your decision, or you will draw conclusions based on the information you have. So basically, you're informing that person that if they're not willing to participate in the process, then you will draw conclusions based on the information you have before you. So
That's really interesting and practical advice. I'm going to go with this question from John. Um, of course, we've talked about the importance of maintaining confidentiality from with all parties, right? The employer, the complainant, the person that might be as, might have done something improper. What if one of the parties breaches confidentiality? Any thoughts on that, Sebastien?
right. So it would certainly depend on the severity or the significance of the breach, and if they have a disciplinary record of sort. But it is generally something that is for which you'll issue discipline. It's a serious issue, and so it's a letter of discipline. If it's a unionized setting, perhaps like a suspension, and in some cases termination. It certainly will depend on the specific facts of that case, but it's wholly improper for a witness to, or anyone who's involved in the process to disclose confidential information related to a workplace investigation.
Okay, another strong question here from Jessica. So this one pertains to notifying the complainant if, in fact, it's deemed there was no harassment. So she's saying the complainant, in the act, the complainant needs to be told what the outcome of the investigation is. Um, but is that only if the investigation determined there was actual harassment?
Right. So in all cases, so under the Occupational Health and Safety Act, the employee, the complainant, and the respondent need to be informed of the outcome. And again, outcome can be just a one-page letter. We've investigated the matter, and further to our assessment of the matter, the investigation has concluded that there's no workplace harassment or no workplace violence in the workplace. So you need to inform the parties of the outcome of your investigation. Yes.
And just to follow up, this isn't a question, but you just made me think. So, if an employer was to conduct a proper investigation, go through the proper processes, determine there was not harassment, um, the employee, do they have any other grounds to appeal that, or any other legal actions that they could pursue at that point?
Yeah, I mean, they could go to, if it's a issue of discrimination, they can always go to
Okay.
the Ontario Human Rights Tribunal. Again, for provincially regulated employers, the same principles will apply for a federally regulated employer. They go to the Ontario Human Rights, the Canadian Human Rights Commission. They could file a civil claim before the Ontario Superior Court. They could file a grievance. They could go to the Ministry of Labor, complaining that there's been an improper investigation, and then an inspector could determine whether an investigation has occurred and whether that investigation was proper in the circumstances. So
Okay.
yes,
So employers really should keep that in mind, that they don't
absolutely,
necessarily have the final say in any of this.
exactly.
I thought this was a different question, and one that I hadn't considered. With work at home workforces, sources of harassment could arise for environmental actors, not just fellow employees. So I guess what they're saying is, typically when we're all in the office together, we might have seen harassment occur between employees. But what if it's an employee and someone outside the company? What is a company or organization's responsibilities then, Sebastien?
Right. So the example I like to provide is the bank teller example. So you've got a customer that goes to a bank teller, and that customer is berating the teller. So although that customer is not an employee, the employer under the Occupational Health and Safety Act has an obligation to protect the workplace, and protect the workplace from risks of injury, physical injury, whether it's the sort of the physical building, or behavior from other employees, or improper behavior from customers or contractors. And so in those cases, the employer has an obligation to intervene. It may mean that consultant, that customer no longer has access to the workplace, no longer is able to provide services to the organization. So the consequences is to have that person cease interacting with that employee or employees of the organization, and to prohibit that person from having any further interactions with the organization. So again, that's just one measure out of many that could be taken by an organization to ensure that they're providing a safe workplace for their employees. So obligations flow just as much as the employer protecting their employees vis-a-vis other actors that are not employees of the organization.
Okay, great answer. And there are more questions, but maybe we'll end up with this one. Let me just locate it again. And it's John, once again, it's kind of a two-parter. So the first part was, in a unionized environment, it's common to see reinstatement in a wrongful dismissal case. And then the second part of that question was down here: is reinstatement possible in a non-unionized setting if wrongful dismissal is found? So in a unionized case, I guess he's presuming, John, that the person could be reinstated. What if it's not a unionized case?
Right. So if you're unionized, an arbitrator has the power, the authority to reinstate an employee that's been discharged, terminated. In a non-unionized setting, other than a breach for one of the protected leaves of absences, for instance, the employee is terminating following their return from pregnancy leave. Employee can go to the Ministry of Labor and file a complaint, and the MOL has the authority, the ability to reinstate that employee. Or in the context of a complaint to under the Ontario Human Rights Code, the tribunal has the power to reinstate an employee that's been terminated based on one of the prohibited grounds of discrimination. But in your classic sort of wrongful dismissal case, employer decides for operational reasons to terminate an employee, provides them with a package, or terminates that employee for just cause. Courts don't have the power to reinstate employees unless there was some sort of human rights issue in play. So that's the answer.
Okay. And I lied. I'm going to ask one more question. Don't
Okay.
hold it against me, because I think this one's really interesting. So Gina's asking, so let's assume it's a non-unionized environment. And if the person that's being accused is the boss, is the employer, the person filing the complaint, who do they file it to? Do they file it to a board of directors? Do they file it to someone else on a management team? That could be a tricky situation, Sebastien.
Right. So if it's so I'm going to assume here this CEO that's subject of the complaint, then you would go to the board of directors. You would file a complaint with the chair of the board, who would then inform the executive committee of the complaint, and then the board of directors would be seized with the responsibility of conducting the investigation. And in that example, the board would likely send that matter to a third party for investigation. That's why it's important under your harassment policy or your any sort of policy addressing workplace misconduct that there be a clear process to address those specific instances. So what happens when a complaint is filed? The employee must go to HR. If the complaint relates to the CEO, where does that complaint go to? So it's important to have clear processes in place to address those issues.
Excellent. Well, listen, we're well into overtime. I predicted this is going to be a popular topic with lots of issues, and that certainly was the case. We're going to start wrapping up. We've got a key takeaway slide, so we're going to bring that up for our producer. And let's talk about some of the key points that people can be reflecting on as we wrap this up, Sebastien.
Right. So 6 takeaways. So number one, as we discussed, not recognizing the need to investigate. So it's important that you be aware that when complaints are brought forward, that you do a proper assessment of each of them. And I gave you the example of an anonymous complaint or an FY type complaint. So it's important to know when you need to investigate. Important to have an investigation plan, to know where you're going, how you're going to go about addressing workplace issues. Not following your policies or procedures or the provisions of your collective agreement. And, I do mention as well, just as it relates to a collective agreement, there may be provisions about the need to have union representation as well during the life of the investigation. Not implementing interim measures. We talked about whether it's a paid suspension pending investigation, transferring one or both employees, having a remote work arrangement in place for the duration of the workplace investigation, not ensuring proper record keeping practices, again, an important takeaway, and finally, ensuring and preserving the privacy and privacy rights of all parties involved. The goal is always to get to the bottom, to get to the truth, and there's no need to share and disclose the context of the investigation. It has to be on a need to know basis, and important to remind all parties involved of the need to preserve confidentiality.
Well, Sebastian, I think whenever we talk about HR and especially employment law issues, there's some complexity. We've had many of these live broadcasts. I think, honestly, on my side, this is the most complex. And for that reason, we're going to bring your contact slide up. So I think if you're dealing with an issue like this, my takeaway is you need professional advice. And don't try to tackle these issues on your own, or it might be a very big and negative consequence on you. So I want to thank you, Sebastien. You've done a great job at keeping this understandable and practical and dealing with a lot of real world issues. So thank you very much for joining us here today.
Yeah, thank you for inviting me, and thank you to your audience.
Okay. All right. We'll see you soon, Sebastien. As we sign off, I want to remind you that we are doing many of these shows kind of on a bi-weekly basis. One of the ways to stay connected to us is to like our YouTube channel, if in fact this is the platform you're watching on, and click the little red bell. And when you do that, then you're notified whenever we're posting a new video. For more general business news and information, I want to encourage you to go to obj.ca. That's our website. We get lots of practical information, news information. We just relaunched the website last Monday. So that's something that only occurs typically every decade or a couple times a decade. So please check that out, obj.ca. And if you're a real hardcore local business news junkie, there's a great way to stay on top of all of this. Subscribe to OBJ Today. That's our Monday to Friday weekday email newsletter. There are thousands and thousands of business leaders in the city subscribing it to you too. I know you're going to say, not another email. Here's the thing. You can scan it 30 seconds, 60 seconds, and get a full recap of what happened in the day in business. So that brings us to the end of our show. I want to thank Eamon Harnden for their continuing support in these broadcasts. They always bring excellent, engaging, insightful, informed experts to us that are helping, I hope, you deal with very real labor and employment law issues. So thanks once again to Eamon Harnden and specifically Sebastien Huard. That's all we have for today. Hope to see you real soon. Bye-bye, everyone. Cheers.